we got a question?
The City Council...
What's your name?
Alex Starr. The City Council has stated over the last year or so that the reason they don't want to go and support this effort to phase out the power plant is the threat of lawsuit. So I would like you to comment on AES's possible positions and the strength of their arguments.
Well, we don't know what the arguments are, and isn't that already pretty telling? But the other thing that I think is extremely telling is that, and it doesn't surprise me, that AES announced 2 days ago that they would not challenge the City Council's decision to allow the voters to exercise their fundamental rights to vote. And that's a good thing. And it doesn't surprise me because there are no legal grounds to prevent the Council from exercising what is a mandatory duty under the California Elections Code and the Constitution to place an initiative that has garnered and has been certified by the city clerk as having sufficient valid signatures, more than 15% in this case. There is no defense to that, to put that on the ballot. So AES has announced it will not challenge that decision. And since the City Council has not refused to put it on the ballot, there's nothing for BBR this time around to challenge. This time around, BBR, and I assume nopowerplant.org, both applaud the City Council's decision.com. Both applaud, sorry about that. Both applaud the, I have another client, and that's .org, so last time I said .com for that. So I seem to get it wrong each time. There is no lawsuit, and then the only other questions that have come up, I think that we have discussed. We feel very confident that this definitively is not a situation where AES is deprived of all economic beneficial use. So there is no categorical taking here. And then the only question that remains is, does this ordinance go too far later on? If later on AES were to apply for a conditional use permit that allows it, that would ask them to ratify repowering. But that's, again, so far in the future, it's difficult to know whether that situation ever comes to pass, because we don't even know what the California Energy Council decides. But even in that case, the question is, does this significant commercial zoning really affect something that is close to no beneficial economic use? And we just believe that that cannot be. Because all we do is place AES at par with the parcels across the street. And I think Jim has explained that very well in one of the many basically Q&As that he put on the website. This allows them 100 and how many thousand square feet?
If it's all retail commercial, it's 130,000 square feet, and if they get a bonus, if they install things like hotels, office space, it goes up to 430,000.
430,000. And so how can you say this doesn't leave them with reasonable use or return or market value of their property if they're being placed at par with the parcel across the street? And for the same reason, by the way, if this question ever came up, this is never spot zoning. This isn't spot zoning. Spot zoning would be if you would pluck them and create uses that are inconsistent with the uses that surround them. And the whole purpose is here to create uses that are consistent. A mix of commercial visitor serving income-generating uses with parkland. And the parkland, in fact, will enhance the open space uses on their property, given that they're being mixed with income-producing uses, will enhance the income-producing uses. Would you rather go to a hotel that is adjacent to a beautiful park or a wetlands area, or one that is surrounded by a power plant or surrounded by commercial development? So an argument can be made, a fair argument can be made, that in fact these commercial uses that the initiative gives AES are being enhanced in value by the open space, by the 60 to 70% open space that would also be on that parcel.
In response to the issue about the potential litigation, as Frank mentioned, we don't know what the potential litigation is. Obviously, anybody can sue anybody anytime they want, unfortunately, in California, or anywhere else for that matter. And without having AES articulate the reasons for the litigation, it's kind of hard for us to answer. But if the issue is regarding the ordinance and whether the ordinance basically is equated to a taking, my take on that is there's more facts that we have to evaluate, but based on the information that we currently have and based on the ordinance, it's highly unlikely. I think the way the takings law works is it's very clear if you basically make the value of the property entirely worthless and take all the use of the property, it's a taking. So if you buy a property on the Strand and you want to build a house there, and the city decides, well, we want people behind that area to enjoy the view, so you can't build a house on that property, that's clearly a taking because you can't use the property for anything else. That's not what the ordinance does here. I know Frank mentioned a case that goes to some of these points. There's a recent case that was decided a few days ago. It's a Ninth Circuit case, and I think it addresses the issue. It refers to various U.S. Supreme Court cases that go back several years. One of them I studied when I was in law school regarding the Grand Central Station, Grand Central Terminal in New York. But basically, it goes as follows. As a general rule, zoning laws do not constitute a taking, even though they affect real property interests. This court has upheld land use regulations that destroyed or adversely affected recognized real estate interests. Zoning laws are, of course, the classic example, which have been viewed as permissible government action even when prohibiting the most beneficial use of the property. So in this case, we say the most beneficial use is a power plant because it's been there for 60 years and they have a plan ready to build it. The court is very clear that that does not by itself constitute a taking. And they go on and explain three factors that the court would evaluate whether or not a taking exists. The first factor is economic impact of the regulations on the claimant. And I didn't know this, but Leslie said it, the claimant we're talking about is an $18 billion company. So it's not a mom and pop operation is going to close down if you change the zone. The second factor is the extent to which the regulations interfered with the distinct investment-backed expectations. The distinct investment-backed expectations that I mentioned earlier. When they bought this property for medicine, their extinct investment-backed expectation was to 2018. That ordinance does nothing to that specific investment-backed expectation. And the third factor is the character of the government action. So if you're talking about the city council or the five gentlemen out there making a rule, somebody can say, well, they made an arbitrary rule, they didn't think about it, that's the character of the government action. Here we're talking about a vote for the people of Redondo Beach that are going to vote on it. And I think that to a court, that's going to be a much stronger, it has a much stronger credibility that these are what the people want rather than five gentlemen in a room making a decision. So if I look at these three factors without having a lot of other issues that AES may come up with, I am at least more than the 50% chance that it's highly unlikely that this ordinance would be considered a taking.
And Hanny just cited a Ninth Circuit case for you, and I'll tell you about a California Supreme Court case. It's an older one, but it demonstrates the point well and probably will get you a little more comfortable that this is not going to be a taking. Again, AES can file a suit. The question is how far will their suit go? And at least for this case, they would not be able to get past a demur, which is an objection to the complaint saying that you have no claim at all. So in this case, it's called HFH Limited versus Superior Court. A property owner purchased a property in the city of Cerritos, and they purchased the property contingent on the right to be able to change it from agricultural zone to commercial zone. And so the purchase transaction would not go through unless the seller got that zone change effected, and the seller did. So the property owner got the purchased property for $385,000, got the zone change, now they're zone commercial, then went and subdivided the property so chopped it up into smaller pieces, and then did nothing with it for about 4 years. After a 4-year period, the city decided that it wanted to rezone the area, and it decided to change that property to residential, and single-family home residential at that. And the property owner had actually entered into a purchase and sale transaction as well, and the purchase and sale transaction to resell the property was also contingent upon there being a commercial zone there. And so now the person appealed to the city saying that the seller, the owner, said, hey, you know, I had this property, it was commercial, I purchased it on reliance of it being commercial, and now you've changed it. You've changed it back to, well, first they changed it to agricultural, and then you're changing it to residential, and that's going to diminish the property's values hugely. They denied. The city planning commission, the city council said, nope, we're not going to change the zone, it's going to be residential. The property owner appealed, took it all the way to the California Supreme Court, and you know, there he demonstrated that he had damages. He could sell the property now for $75,000 as it had been rezoned. And the California Supreme Court said, hey, you haven't lost total use of the property, that you know, you don't have the right to use the property any which way you'd like. And they got into this thought about, was the decision by the city council arbitrary? And here's the irony, actually, the kind of unfair part, is that every property around this property had been zoned commercial now, except for this area, this tract. But was it spot zoning? So what the California Supreme Court said that is, this shopping center, which plaintiff seems at various times to have contemplated erecting, would derive its value from the existence of residential housing in the surrounding area, and that was the previous zoning. The residential character of the neighborhood, we may assume, results in part from the residential zoning of the area around the tract in question. Plaintiffs in this case therefore find themselves in a somewhat uncomfortable position. They wish to reap the benefit in the form of higher market values of their land, of the restrictive zoning. They want to remove the restrictive zoning, but do not wish to bear the reciprocal burden of such zoning when it applies to their property. So what they're saying is, look, now there's all commercial property around you, and for those commercial properties to succeed and thrive, they need a neighborhood, right, to be there. And so, you know, they're saying this functions for the general well-being of the city, and it's not just discriminating against that property owner. And yes, you've lost some value, but here, you know, they hadn't erected anything on the property. They hadn't acted in reliance. And as Hanny explained earlier, there's an amortization period that's going to exist here for AES by the time this comes into effect, and the zone change will occur after the expiration of their contract and after the expiration of their return on investment. So the likelihood of a takings lawsuit on these facts proceeding past a demurrer is very low.
And I would also add a consideration why in the very foreseeable future, my prognosis would be they would not file a takings lawsuit because their attorneys would tell them it wouldn't be ripe. There is such a concept as the ripeness concept. And how can you decide whether conditions, how can you decide in 2012 or 2013, next year, if this initiative passes, whether there will be a taking 8 years or more later? It's impossible to decide, because at that time, what will be the value, the income, the value of their property based on power generation as opposed to commercial uses? And there's just too many unknowns. By then, the energy prices may have collapsed, for all we know, or they may be different for all we know. There will be, at least here in California, a much greater mandate on public utilities, which we already know now will be increased to 33%, of renewable alternative energies. There may also, by then, we don't know what the electricity storage capabilities will be. There's flywheel technology that could be very promising. There's other technologies. From here to 8 years down the road, there may be technologies that may render this plant even more obsolete than it is now, may render it completely obsolete. It is true that now a few peaker plants are needed, but there's already more peaker plants, and this summer has demonstrated that we could do without something much bigger than a peaker plant, that we could do and survive without San Onofre. But that situation may be even more dramatically changed 8 years from now. So I would guess that if a takings lawsuit was brought in 2013 after this initiative measure passes, it would be out on a demurrer on ripeness reasons alone within a few months of it being filed.
So